Welcome to the NYU Law Forum. On March 13th of last year, FireEye, a prominent cybersecurity vendor, revealed a global supply chain intrusion campaign, doing something called Trojanizing the SolarWinds Orion business software update. And these attacks compromised they used multiple techniques to evade detection, and it affected public and private organizations around the world, later described as compromising 18,000 Orion software customers, including 9 federal agencies, an act that was attributed to a Russian foreign intelligence agency. There's a lot to unpack here in this short summary, but luckily, thanks to the Reese Center for Law and Security and the NYU Center for Cybersecurity, we've got an all-star panel with us today to do just that. My name is Randy Milch, and I'm a professor of practice at NYU School of Law and co-chair of the NYU Center for Cybersecurity. And we have a group of distinguished panelists with us today that can bring unparalleled expertise to all corners of this SolarWinds attack. We have Ed Amoroso, who's a research professor at NYU Tandon School of Engineering, and importantly served as the chief security officer of AT&T from 2004 to 2016. We have Kristen Eichensehr, who's a professor of law and director of the National Security Law Center at the University of Virginia School of Law, and has spent time advising the Department of State and others on international law matters. We have Judy Germano, who is a fellow of both of our sponsoring NYU centers and is a sought-after attorney in private practice to parties who have suffered cybersecurity breaches. And we have Aaron Hughes, who's the group vice president and chief information security officer at the Albertsons Company, and importantly was the deputy assistant secretary of defense for cyber policy from 2015 to 2017. So with these experts, we have domestic, we have international, we have private, we have public, we have policy, we have technology, and we're going to spend some time talking about SolarWinds today. I do have one last obligatory statement. That is that we have, for those seeking CLE credit for attending today's session, the panel has been approved for 1 New York State CLE credit in the category of areas of professional practice. The credit is both transitional and non-transitional and is appropriate for both experienced and newly admitted attorneys. At some point during this panel, we will display a course code that attorneys seeking CLE credit will need to record. After the panel, attendees will receive an email with an attorney affirmation form where they can submit the code for CLE credit. You do not get CLE credit for listening to the statement about CLE credit. Okay, let's begin. Ed, I want to start with you for a second. Give folks in brief outline some sort of a summary of what this, what a supply chain attack is and how it Trojanized the Orion business software updates. What does all that mean? Give us an explanation.
I'm happy to go through very, very quickly. For people who want a longer explanation, there must be 1,000 websites and listicles and other kinds of diagrams explaining what happened. But I'll try and give it to you very quickly. Nation state went after a company that sold to a lot of other downstream customers. So in a sense, you call that a third party attack because what's happening is you're using the distribution method to gain access to the customers. You're not going after a bank directly, you're going after the company that supplies software to the bank. So that's the first sort of principle here. What they did was actually pretty straightforward, but well executed, and nation states are darn good at doing this. They know how to tiptoe into your network or your enterprise and not leave any tracks and do these things very cleanly. But they managed to get Trojan horse software, essentially malware, into the update software that this company SolarWinds that does IT management. It's a company that's very successful, a large footprint, particularly as you read in the media, with civilian agencies of the United States seem to have a very heavy footprint there. So I got the Trojan into the update code and the small footprint for the code, digitally signed, looks like a normal piece. And then it goes shipped off as part of the update to all of the customers. The thing sat there dormant. Like if you've heard the designation APT, Advanced Persistent Threat, the P means persistent. That means you hang out and lay low for a little bit, which is what it did. I think it was a couple of weeks or so. And then it starts gathering up some information and essentially phoning home in configuration files. So it all using standard protocols, it just hops aboard and piggybacks onto a process that looks very normal. So extremely well executed and provided remote access to the footprint that SolarWinds had from a customer perspective. And, luckily FireEye, a security company, tangled into this whole thing, picked up on it. People always ask me if FireEye hadn't picked up, would still be running. I think eventually we would have figured it out, but it's entirely possible that we would be having this webinar about a different topic. So we're sort of lucky that we picked it up. And well, I'm sure we'll go into more detail, but those are the crude sort of details or high level details of what happened. And as I said, anybody with a browser can Google any number of different videos and other more detailed explanations of the incident.
So one further question along this line is, as you think about it from a security expertise standpoint, does it strike you that being able to infiltrate the Orion software, which has a certificate, which if you explain that for a second, that would be helpful, which has a digitally signed certificate with the update, does it strike you as indicating that SolarWinds was particularly negligent, that this is indicative of horrible processes there, or is this one of those there but for the grace of God go I sort of situations?
It's the latter. The software process used in most companies today follows more or less a templated methodology. We use terms like DevOps and so on to describe the agile nature of how we do things, how we develop software, we distribute it, we use it, we get feedback, we update. It's a very comfortable process. And I don't think SolarWinds is doing anything that's better, worse, or in any way adrift from what most of their competitors or other software companies do. This reference to certificates, that's using cryptography to digitally sign something using key information that you store locally. So you have a private key, you sign it, you stamp it, and it's from me. So Randy, if I were sending you something over snail mail, it'd be like my personal stamp on it, and you see it, it's me. Well, all you have to do is, if you're infiltrating the inside method of how that's done, then you just climb inside that process. And that's what SolarWinds did. So essentially things were getting stamped after the infiltration was already done. So really, in some sense, that hashing becomes useless. So, but I think your question about whether there's something out of the ordinary here, I think as our other panelists, I'm sure will attest, sadly, this rhymes with a lot of other attacks that we've seen. And I hope it doesn't continue to rhyme with an ongoing stream. We'd like to see this change. So people who are listening today, I hope you'll be part of the next wave of reducing risk of these things, because they do happen quite often now.
Okay, thanks, Ed. Well, Kristen, it's been attributed to a, quote, Russian foreign intelligence agency, close quote. So let's start off right there. What do you think about attribution in this thing? What's important about knowing who did it as opposed to the fact that it happened? Why is that important?
Well, I think it's important for a couple different reasons. And in your citation there of this has been attributed to a Russian intelligence agency, that's been true with respect to companies that are involved. It's been from private sector actors, they've attributed it to the Russian intelligence services. The US government has been cagier about that. They've said that it's a sophisticated actor, likely Russian in origin, and that's as far as they've gone. So I would expect to see in the next couple of weeks a more detailed attribution from the US government, probably coupled with the response that they keep promising will be forthcoming in the next couple of weeks. So we'll see what they say. But I think, from the perspective of knowing who did it, it's relevant for a couple of reasons. One is maybe better helping sort of network defenders understand what's likely to come, what's the purpose of this attack. And if you see a nation state actor, the idea that they would be engaged in espionage and looking for high value information on US government systems, that fits pretty well. The other reason it's important is because the attribution to a nation state may make the international law analysis look a little bit different. So certain actions can only be taken against other nation states. And so if you have a criminal group with no tie to a nation state, that kind of limits response options in a way that, at least potentially, if you can assign responsibility to a nation state actor, it brings in different kinds of response options, notably countermeasures. But that leads to a whole other series of questions about how do we categorize what actually happened here, and what is this attack as a matter of international law.
Well, I'll get to that in a second because I do want to talk about that. But I thought it was interesting that you pointed out that the government's been, on the one hand, it's been cagey about attribution, but on the other hand, they almost immediately promised a response. So if it weren't a nation state action, why would they be promising a response? Doesn't that sort of betray the hand that the government too almost immediately decided this was a nation state activity?
Yeah, and I think that that's right, that they've telegraphed very clearly that these private sector attributions that we've seen that are more specific, I think that the US government has telegraphed pretty clearly that they agree with those. But I think what we'll see, what we typically see with respect to government attributions, is that they often come in the form of indictments or economic sanctions. And when that happens, they are more directly targeted. So an indictment would be directed at a particular person, sanctions might be targeted at a particular entity within a foreign government or at particular individuals. So it may be that what's happening is that the government is building their case for, very specific attribution for an indictment or for economic sanctions. But it is notable that they fairly quickly here did come out and say that this was likely Russian in origin, and are signaling pretty strongly that they agree with the more specific attributions we've seen coming out of the private sector.
So are you anticipating then our response is not going to be a cyber response, but it's going to be an indictment of people who will never come to face justice, or sanctions on people who are sanctions on people or entities?
I think it's going to be probably all three. I mean, I'm reading the same reporting I'm sure everybody else is seeing about counterstrikes against Russian targets. So I think there are pieces of this that will come out. We'll learn something about the cyber response through media reports, but I think we'll also likely see indictments and sanctions. Maybe not all at once. The way the US government has worked in the past is that they tend to kind of roll out these different mechanisms over time. So you might see a public statement that attributes an attack, and then a year later you get an indictment and sanctions, or sanctions and then an indictment. Sometimes it's taken, in past state-sponsored cyber attacks, it's taken years, but usually that's the cluster of things that end up being publicly disclosed, as opposed to all the other things that may be going on that we don't know exactly what the responses look like and that aren't going to come out publicly.
So let's go back 1 second to the point you left open, which was, okay, if it's espionage, what are our responses to espionage? And it does seem like, unlike the more recent Microsoft hack, where people immediately started abusing it for ransomware purposes, which had a sort of an immediate real world effect, this did seem to be an espionage attack. This seemed to be finding places to gather information. What is that an act of war? I mean, every time one of these things happen, you can rely on someone in the Senate going, "This is an act of war and we need to retaliate, da, da, da." Is this an act of war?
No, it's not. It's very clearly not. There are a lot of things that could have happened here that would have been a whole lot worse. And so we need to reserve that top category of act of war for things that actually meet that criteria. States have kind of coalesced in the last couple of years around a standard for what counts as a use of force or an armed attack in cyberspace. And it's something, the standard that's used is scale and effects. So this is cyber war, cyber armed attack should be reserved for things that have a cyber attack that has the scale and effects similar to a conventional attack. So we're talking serious injury or death to people, very serious damage to property, something like that. This is not that. This does appear to have been just espionage. Now, in saying just espionage, we'll see what exactly the United States says. So Ann Neuberger, the Deputy National Security Advisor for Cyber and Emerging Technologies, said in a press conference a couple of weeks ago, she said, "This is more than a single incident of espionage. It's fundamentally of concern for the ability for this to become disruptive." So I think I think maybe what's happening is that the United States is sort of struggling with how to describe this, because when it happens to the United States, the US government doesn't like that. On the other hand, this does look very much like traditional espionage, and that's something that the United States engages in as well. It's something that traditionally has not been well regulated or regulated at all under international law. So the United States might be about to come out with sort of a different characterization of this. We'll have to sort of wait and see what they say. But to the extent that it does appear to be espionage as opposed to disruption, that's something that a lot of states engage in, and it's very hard to deal with as a matter of international law.
So Aaron, let me jump to you for a second. Putting your old DoD hat on for a second. So we've got something that has gone after agencies in the government, and Ed described what they did. Why is the government prone to this same problem? Shouldn't the government be doing something that prevents this sort of attack, or should they be at a higher standard?
So I'll get to that. I do want to sort of dovetail into what Kristen was describing, because I really struggle with the connotation of attack in this context. I mean, I think what the Russians did was an intrusion, which led to espionage. And to the degree that like attack is a form of the discourse, like it leads folks to think that there will be sort of an attack in kind. Again, I'm not sort of privy to any classified information. I'm reading the same open source, but I suspect sort of the response will very much fall in the sanctions and sort of maybe like indictment category, and less of sort of any active cyber measures, is if I had to give my opinion on that. Like, this is from an intrusion and an espionage perspective, again, sort of damaging for the US government, damaging for our corporations, but something I think we would, as US citizens, hopefully be trumpeting if we were able to sort of similarly gather information from our foreign adversaries. Now, back to your original question, Randy, like, how does the US government protect our infrastructure, the integrity of our networks? I mean, there are some sort of very basic certifications and accreditations that GSA sort of manages on behalf of US entities. Like, sort of NIST puts out standards, for FedRAMP, for sort of cloud security providers. There's sort of generally the arc of like FISMA compliance and sort of, again, various NIST standards. Now, I think when you are installing software on national security systems, there's sort of an additional sort of level of interrogation of those software before that's deployed. That's controlled by sort of NSA and other entities. But the federated nature of sort of any of these software accreditation processes leaves it a bit sort of fraught for varying levels of compliance and decisioning before you get what's called the ATO, the authority to operate sort of that software on a government network. I'm not sort of certain sort of the level of resourcing that GSA applies when they do an analysis of a particular software vendor. But again, given sort of the vastness of the networks, the probably the pushiness of like the software vendors, and sort of saying we attest that we meet to these standards, I think it's certainly an area that Anne and her team will probably, in the various CIOs of the government, will be looking at to improve in the near future.
Okay, so bottom line, no, in other words, there's not.
Long-winded way of saying no.
Okay, I just wanted to be clear that and is that the same as true at DoD? I mean, did you guys have Orion software at DoD, to best your recollection? I mean, it's really popular.
I mean, so it certainly, I don't recall from my time, but for what I've read, it was not in use in sort of any sort of sensitive places that would have been impacted by the incident back in December. But again, just sort of, you think about the impact of sort of any third-party software. You're to Ed's point, like the underpinning of the internet is based off the trust of these certificates. You're trusting that a vendor is sort of evaluating their software development processes such that the code that they've written is the code that they have tested and evaluated and deployed. And I think sort of any third-party risk analyst is going to be sort of hard-pressed to say or push back on the supply chain. It's just a sort of a very sort of difficult way to to sort of conduct exploitation. And that's why this one was tied back to a nation state with, as reported, thousands of engineers working on it. Again, just a very difficult place to come in the kill chain.
Okay, so Judy, if you were advising SolarWinds, okay, what would you tell them about their liability for this oops? What would you be telling them?
Well, we'd want to look at the contracts and see what limitations on liability are already in there for these types of situations. But it's a concern. Right now, there's one shareholder derivative action that's been filed against SolarWinds and its CEO and CFO, or former CEO, saying that they should have done more and misled. But the complaint focuses on 2019 disclosures that SolarWinds made that said this kind of thing could happen. And this is a very serious thing that could happen. So the fact that it happened, it had previously been disclosed as a risk and a possibility. But in terms of what happens next is still a question, because we still don't understand the full scope of harm from this attack and what damages will flow from the attack, because it was done in such a nefarious way. It was described as artful in the deception and how they were able to cover their tracks and hide. And once they got in the systems through back doors, moving laterally. But as for liability, there's also going to be questions about attribution, because something that's very interesting is they were able to trace back who downloaded the tainted update that had the malware in it. But there's also about a quarter of companies that have the same malware that didn't download the update. So there are other means that that these problems are coming, and not directly through SolarWinds. So we would have to explore what specific harms directly attributable, and I think we won't know the harms possibly for years in terms of the extent of this. And then how do you tie that back to this particular incident? And what do the contracts say in terms of limitations on liability and the prior disclosures that SolarWinds made? If we flip that, though, just on the other side, there have been some concerns of why SolarWinds did not have a CISO, why there wasn't a director of security, questions about the SolarWinds 123 password, how that could happen in such an important high-tech company that had such a role with a majority of Fortune 500 companies and key government agencies, and as well as international customers of very high value. So there will be a balancing of responsibility and liability, but it's not a clear, quick question or answer.
So it's always those pesky interns, right? I mean, they're the interns definitely taken in the neck whenever these situations seems to come up. I'm glad I'm past that stage. Flip it around. Say you're not counsel to SolarWinds anymore. You're counsel to one of the Fortune 500 companies that put the software, took the update in, put the software in. It was one of the many thousand that where it seems as though the software was left unused, right? I mean, it seems as though the perpetrators actually sent kill messages to many thousands of places and didn't even try to exploit the software. Are you advising them to sue? Are you advising them to look to their insurance? What's the big whoop?
Well, again, it goes to questions of harm, since this wasn't an attack that was financially motivated, but rather was a situation of espionage and access and information. As a company who downloaded the software, would you really want to get into a big hot mess of litigation, which also would take years and make you very public? Because right now we also have unclear issues as to disclosure obligations. Because personal information may not have been accessed, it may not trigger all the different state data breach notification laws and international notification laws. If it's not materially impacting your financial systems, it may not trigger your SEC disclosure obligations. So then the question is, maybe you just work it out with your own insurance company, put a lot of resources toward detection and remediation and making sure that they're out of your systems, if, to the extent possible, but not get into a big, long public litigation with SolarWinds, which is going to wind up costing a lot of money and be a major distraction for the organization.
Okay. All right. So let's step back one step. As Ed pointed out, if FireEye hadn't stumbled upon this, we may well be having a webinar about the Microsoft Exchange. Right? That would be which some people, including Dmitry Alperovitch, say was a much more troublesome, dangerous sort of an attack than SolarWinds turned out to be, because of its how adept they were and the steps that were taken not to call attention to the attack by actually limiting the attacks that were undertaken. What do we pursue? I think everyone says thank you, FireEye, for making this public and doing a public service. Do they have any obligation? What kind of obligation should we look to for a company like FireEye as a matter of policy? Kristen, what do you think about? Do you think that there ought to be and I'm interested in all of the folks here coming back on this. Is there some sort of public obligation for a company like FireEye to do this sort of after all, they admitted that they were hacked, right? They were a victim, which is, what do we think? Kristen, why don't you start off if you have a view about this as a sort of a public policy measure?
Well, you've got the public policy question, or the sort of maybe the moral question of, do they have a duty to sort of the system, given their important role in it? And then you've got the legal question. So for some companies, they are, if they're publicly traded, they have disclosure obligations with the Securities and Exchange Commission to report material events. So for some companies, we get SEC disclosures, FireEye, simultaneous with sort of the public announcement that it had been hacked, filed with the SEC as well. So that that's one way to think about this, is just from the straight legal question. But I do think we are seeing companies fulfill kind of a public service here. I mean, even if they're not under a legal obligation, turning to, in the Microsoft Exchange hack, another company turned to Microsoft and told them about the vulnerability, and Microsoft, then addressed it. So we're seeing public disclosures, and we're seeing, remediation start because of the role that these private companies are playing, which I think is a fascinating one. Like you said, we might be talking about something completely different if FireEye hadn't made these disclosures. So they're not required most of the time under US law, unless, as Judy mentioned, you get a compromise of personally identifiable information, which triggers data breach laws, or unless they happen to fall under the Securities and Exchange Commission requirements. So there are some pretty big gaping holes in the legal requirements for disclosure. And I do think that's an area that is going to probably be rethought in the next period, as we are beginning to understand how important the private sector actors are in recognizing some of these attacks that are mostly targeted at the government and also at other private sector actors.
So let me turn to you, Aaron, for 1 second, because one of the things that Kristen said that was interesting, which takes a little bit of the rosy bloom off of FireEye, is that someone determined, one of their SEC lawyers determined that they had to make a public filing. So I guess they figured, one could argue, if one were cynical, that since they were going to make a public filing anyway, they might as well make this big splash about doing everyone a favor for alerting them to this, and make a little bit of a virtue out of a necessity. What do you think? I mean, Aaron, as a CISO of a private company that is main business is not cybersecurity, right? What do you think about an obligation to you at Albertsons to have to make alerts that you have been intruded upon when nothing has been stolen from you, no private information has been stolen from you, and it's not material to your books? Do you think you ought to be out there, have an obligation to be out there telling everyone?
So, well, I'll give you the quick answer of no on that, but then I'd love to sort of pivot back to the FireEye perspective. Again, I'm not a lawyer, I'm a security practitioner, but the PR dimension of this for FireEye is tremendous, right? Like, they're already in the business of being viewed, and their sort of mandate FireEye divisions of being technical experts. If they're now able to assert that they were able to identify a very sophisticated nation state actor, that does nothing but like build their credibility in books. So while I'm sure they had sort of true intentions throughout, it does benefit them to be sort of first mover in disclosing the sort of TTPs and methodologies that this particular actor used to exploit the SolarWinds supply chain, which is why you saw sort of the fast followers and CrowdStrike and others do their very detailed sort of blog posts about how the same actor had tried to exploit their networks. I think this one is sort of unique in that area where the fact that the adversary tried to attack the sort of security industry made their motivations to disclose how they found in the event that, you know, FireEye was hacked as well, a little bit sort of different in the true sort of information sharing dimension of it. Which I think is just unique in this circumstance, that now sort of more less sophisticated companies, be that Albertsons or others that aren't sort of security first, are going to lean more on the CrowdStrikes, the FireEyes, and others for this sort of business.
Hey, Ed, what do you think? You're in your alter ego is, you know, you're double hatted here. You've got Tag Cyber, which is a noted cybersecurity firm. What do you think about an obligation to be the public voice on these things?
Well, let me offer perhaps a somewhat alarming view around this. I think that when we see these attacks, like Microsoft's the attack on their Exchange servers and SolarWinds, it's sort of like we're dancing from the tip of one iceberg to the other. We're scanning the surface of water. We see the little tips, and we focus on the tips, not recognizing that it's not the tip. It's that if we lowered the water, we would see that there are massive, massive mountains of problems that are happening in ways that probably are invisible. I fundamentally believe that a lot of these questions are somewhat moot, only because I think that there's so much cyber offensive activity occurring at the nation state level that we need a complete rethinking. Like, think about it. If you're a nation state, you know, it could be that one of your objectives is just to create chaos, get this company suing that company, and get all of us figuring out, you know, should a FireEye do this? Should SolarWinds be liable for this? And just create utter chaos. And this is sad because nation states can more or less do whatever they want. We all know that. If a nation state decides they're going to go after something, they're 100% successful. So my feeling is that there's a problem, a massive problem globally that may not be as big as, say, climate change, you know, challenges that we've got, but it approaches that category where we need to fundamentally rethink and simplify the way we do computing. And that's a heavy lift, but it's the only way out of this. We need to distribute and virtualize and simplify and streamline and move away from the way we do things now, because right now, I don't think there is a single enterprise in business or an agency serving civilians that can stop a nation state attack. And I believe if you got 20 cybersecurity experts in a room, you'd have 20 of them nodding their heads saying that that's true. So that is the real problem. And these questions, to me, again, the image, the visual metaphor that comes to mind for me is dancing from one tip of an iceberg to another, you know, ignoring what's under the surface.
Okay, so let's go back for a second to Kristen in the international law question here for a second. One of our listeners has obviously studies this to it well and is asked about, first, should we consider this espionage attack a violation of U.S. sovereignty, as an initial question, and then secondly, how is it lawful to take countermeasures or respond once the sovereignty violation is over, right? If we have fixed it, and that's an open question, I guess, but if we have fixed it, is it lawful for us to go after whatever Russian state actor we think has wronged us?
So this raises some very interesting and very debated questions under international law. There is a pretty well seated disagreement at this point between states about whether violation of sovereignty, so a cyber incident that can actually violate a state's sovereignty, and whether that violation is a violation of international law. So we already, you already asked me, was this a cyber war? No, definitely not. So if you kind of run down the chain of international law violations, is this a use of force or armed attack? Definitely not. Next down the list is a violation of the prohibition on non-intervention. So the elements of that are that there has to be an intervention by a state into another state's domaine reservé, which is sort of governmental functions, things like conducting an election, territorial sovereignty to a certain extent. And so one is domaine reservé, the other is coercion. So is this coercive? Again, another area where there's not very much agreement about what coercion means. So we don't know the exact bounds of intervention. Then below that is this question of a violation of territorial sovereignty. And so states have fragmented over this question. So the United Kingdom came out in 2018 and said very clearly, basically, there's no such thing. Sovereignty is a principle of international law that informs these other violations, but it's not, there's nothing below intervention effectively. So there's not this category of violations of sovereignty. The US also seems to lean in that direction. In a speech at the US Cyber Command Legal Conference last March, so March of 2020, the DoD General Counsel basically signaled US agreement with the UK approach and said the US, pretty clearly said, though not as clearly as the UK, that the US also doesn't think there's a violation of territorial sovereignty. A bunch of states have lined up on the other side of that. Germany, France, the Netherlands, a whole ton of states are sort of signaling that they do think there's an independent violation of sovereignty that's a separate international law violation. Now, for those states, there's still a question, though, about, okay, so if you think that that is a category of things that can violate international law, does SolarWinds count? And even for states that think that there is such a thing as a violation of sovereignty in the cyberspace, it's not clear that SolarWinds would meet that threshold. And so, the question is this serious enough? Does this have the kind of effects that we would be looking for a violation of sovereignty? And it's not at all clear that it does. So if you think that this looks more like espionage, there's nothing about this that changes the nature of the intrusion, changes the kind of harm we're looking for, then you're left with the conclusion perhaps that this does not violate international law. And if that's the case, then a state cannot take countermeasures in response. So countermeasures are actions that would be unlawful, but for the prior unlawful act. So a state can only take countermeasures if it has previously suffered an unlawful action by another state. So if SolarWinds and things like it don't violate international law, then they don't trigger a right to take countermeasures. So where does this leave us? Well, you also need to apply the same sort of analysis to a response. So if what the United States wants to do in response is indictments, sanctions, and public attribution, those are things that are permitted at any time. As an international law matter, they'd be called retorsion. You don't need this prior unlawful act. So those are all fine. You get into a more of a gray area when you're talking about sort of more forward-leaning cyber-based responses. So hacking back, taking servers offline, doing things that are going to cause effects in foreign territory. So then you have to run this analysis again. If you're a state that thinks there is no such thing as a violation of sovereignty as a separate category of international law violation, those things probably going to be fine. They would also not trigger any sort of violation of international law. So if you're a state that doesn't think that violation of sovereignty is a thing, if you're the UK or probably the US, then you're kind of below this threshold. And we're in this very contested gray area where international law doesn't have a lot to say. If you're on the other side of that debate and you're a state that thinks that there is something called a violation of sovereignty, this analysis gets in some ways easier because maybe you can say SolarWinds is a violation of sovereignty enabling countermeasures. And that brings up the second part of the question, which is, well, for how long afterwards can you take countermeasures? And that's a question of international law. Countermeasures have to be directed to getting the state back to compliance with its legal obligations. But so this basically, the question raises this big debate that's happening between states over where exactly the threshold is for illegality in the international system.
So it sounds like the US and the UK are in favor of a big gray area so that we can do the same thing to other people.
Yeah, I think that's fair. I mean, the US a couple of years ago, and I'm sure Aaron can speak to this, came out with a policy from DoD of quote unquote defend forward. And the announced goal of this policy is to defend forward closer to where adversaries are operating and by necessity outside of US government systems. So the US has an announced policy of leaning into this kind of gray area.
So this mimics the debates that happened between the Western Bloc and the Eastern Bloc during the 60s about use of force, right? About the proxy uses of force and who, other countries wanted to say economic sanctions were a use of force and the US saying no, this sort of, it is a way to leave the US with greater field of a greater set of opportunities and options in comparison to countries that couldn't exert economic force, for instance. So it sounds like we're sort of revisiting the same sort of division of wanting to leave more opportunities open to certain countries like us who take them. And then you have countries like North Korea, which aren't going to obey any rule anyway. So what difference does it make, right? I mean, it's interesting that places like Germany and France, which must have offensive cyber operations, want them to be illegal.
Yeah, the French position came out of the French Ministry of the Armies. So it's effectively out of DOD. It's not clear whether it really represents the position of the entire French government, but yeah, there is a similarity to the older debate that you're pointing to. But I mean, it's also, I think, worth keeping in mind here that who are these attacks? Maybe we shouldn't call them attacks, these incidents being attributed to often China and Russia, which in some ways are huge proponents of sovereignty on the international stage, but we see them acting in ways that are violative of sovereignty for states that think that that's a rule. So in some ways, the US and China and Russia are, I think, arguing for a similar legal standard. They are not the countries that are out there saying we need to set a low bar for what's illegal as a matter of international law.
Okay, we're going to take 1 second here to show those seeking CLE the secret code. Elizabeth, can you show the secret code? There it is, Forum 3898. If that is your number, you have won 1 hour of CLE credit in New York State. Again, Forum 3898. And if that's your lucky number, say bingo and write it in the question section. All right, Elizabeth, thank you. We've taken care of those folks. Okay, Judy, let's switch to insurance. How is insurance how do we think about cyber insurance? It's become a big deal. Probably all the Fortune 500 companies that have been attacked have cyber insurance. I don't think that DoD has cyber insurance, or any of the government agencies have cyber insurance, but I guess it's possible. How is SolarWinds thinking about insurance? How are the people who've been hacked thinking about insurance? And how does this whole discussion we've had about active war play into the insurance question?
I think what we've seen in the insurance sector is that it's continued to evolve as the types of attacks have evolved. So I wouldn't be surprised if months or a year from now, we sit and talk about the new version of insurance that deals with this espionage, not active war, but not for profit kind of amorphous situation that we're dealing with. But at this point, the estimates, BitSight estimated $90 million as a cost for insurance, but that does not include all of the high value government actors, most of whom those agencies don't have cyber insurance. And it may not fully contemplate the scope of how long this is going to take. So in terms of SolarWinds will need it for remediation and defense on lawsuits and other things. Notice others also for remediation costs, forensic and legal advisors walking through the situation. Here, I would say that the best focus for resources is on seeing, are the attackers still in your network? What have they taken? How do you try to get them out? In certain highly sensitive situations, it may require rebuilding certain systems and putting information in a sectioned off, safer environment. But on the active war question, I think it's easier to think of this and I agree with Kristen that it's not an active war. Thinking of this as old-fashioned spycraft. A foreign adversary would put individuals in different companies and in different government agencies to move laterally and gain whatever information they could get. Here, because of our current lives online, you can do that at such a greater scope and scale, and that's what makes this terrifying. But I think we'll just see more and more of this, and I wouldn't be surprised if insurance changes to figure out how can they address the situation. And it should be then more risk focused, risk management, what kind of steps are in place in an organization to shore it up.
Randy, can I jump in here too, just to
Absolutely, please.
pick up on something Judy said there, and also one of your early questions to me about attribution. I do think that the intersection between attribution and the cyber insurance question is a really interesting one, and more generally between attribution and the US courts, because we've seen litigation over the NotPetya cyber attack from a couple of years ago that has been attributed to Russia. And when certain companies that were badly hit in that attack went to invoke their cybersecurity insurance policies, the insurers denied coverage and said, no, basically active war point. So, in that case, it was because it had been attributed to the Russian government. So again, here, the interaction between attribution and state-based action makes this question interesting and I think different. And I agree with Judy. I think we might see some changes to insurance coverage going forward as a result of that.
And if I may just add, though, the fine point on NotPetya, where we could distinguish it for insurers, is there really was damage, and in fact, physical harm to people from those types of attacks. Whereas this attack seems very much information gathering. But I say that with a caveat: we don't know where this is going still, or what may come next. What kind of information was taken, given the high value of the targets and the ability to hide what they were doing. So it remains to be seen.
Yeah, it's very interesting to raise the NotPetya, the Mondelez lawsuit, which is in state court in Illinois. And as Judy says, the policy was about physical, was as much about physical damages and there was a war, right? The Russians and the Ukrainians are at war, so this is almost bystander damage to these companies. It's a very interesting question. When you both say, Kristen and Judy, that you think insurance is going to change, should insureds therefore say, oh, great, my insurance is going to cover more things? Or do you think when you say insurance is going to change, that means that there's going to be less things that are going to be covered? Because to me, it only really goes one way, but I'm interested in your views.
I think that it will get more specific. And so you'll need another version of a policy for this type of scenario, which means it covers less things, though you'll have to buy something else to fill that gap. Kristen?
I completely agree with that. I think it'll be more specific, and it'll, I'm sure, be escalating in cost to cover different kinds of attacks. And as we see more and more of these attributed to governments that are hitting wide swaths of companies, I think that'll be sort of an add-on to the policy, or an additional policy that's bought.
So there'll be an amendment to the old policies that says it doesn't cover update breaches, and there'll be a new policy called the update breach policy, which I guess is how we're doing. So Aaron, are you involved in, as I assume you are, in Albertson getting its insurance policies? Cyber policies?
So I will be for the next renewal. Given I just joined in the last 6 months, I think their policy was sort of already formulated, but I did get the background and sort of how they provided sort of the documentation and validation of our processes and information that went into our most recent policy.
And are you anticipating actually seeking update insurance specifically as a result of this? Are you changing your thinking because of the way this attack unfolded, or do you, without revealing anything secret about or proprietary about Albertson's current policy, is this something that do these incidents iteratively change the way you think about insurance, and you want to be sure, the last 4 bad things happened last year, I want to be sure they're covered this year?
Oh, well, it's certainly something I would engage our legal counsel in discussing, right? And I think that's why sort of any big corporations have lawyers that partner with the practitioners to determine sort of the best areas that we need to insure and prevent risk for. Yeah. I'd love, if I could for a second, Randy, maybe
Sure.
to pivot and steal a little bit of your sort of moderator or the audience questions. One thing that I had hoped that we would get into, and I'd love to hear the perspective of the group here, is the fact that the Chinese and the Russians, if they're purported to be the ones conducting sort of the most recent attacks, took advantage of our laws that impede some of our national security institutions from tracking what's happening domestically, and sort of pivoted that against us. And that's why we had the FireEyes and the CrowdStrikes and the the security company that was in Northern Virginia that notified Microsoft of this activity, right? Because the National Security Agency is blind to some of that activity domestically here in the US. I think that speaks to the need for the information sharing and maybe the more prominent role that sort of threat intelligence companies can play domestically. But I'd love to hear a little dialogue if, yes, that's okay and the way it should be. We want to continue to make sure that it's foreign intelligence that's coming out of NSA or others, or we need to shift more budget to FBI to sort of cover down on this domestic blind spot. But look, given the nature of how the internet's architected, given sort of how all these cloud service providers infrastructure is structured, I think this is going to continue to be sort of the way that foreign adversaries take advantage of our laws to exploit, private companies and U.S. government information.
Well, let's pivot to information sharing. We got 9 minutes left. It's a small topic, so I'm sure we'll be able to cover it exhaustively in 9 minutes. One of the things that's come of this is as I think we mentioned earlier, is the both Brad Smith at Microsoft and I think Alex Stamos said that we need to have, as Kristen alluded to, sort of an incident reporting obligation. Some people have compared it to the NTSB for plane crashes. Perhaps it's a little closer to the FAA, early warning system that they've put in for incidents. But what do people think about, on the one hand, information sharing seems to be important. On the other hand, you have people who routinely say that information sharing is not a panacea, and most of the people who would get the information wouldn't know what to do with it if they got it. So where do we think about this? Where do you think that, every time we talk about information sharing with the government, it is really a World War III type of thing? If all you have to do is witness what happened with CISA, which is the Classified Information, the Cybersecurity Information Sharing Act, which was a huge battle. So, Kristen, what do you think? Should we have more forced sharing? You talked about the big holes domestically on the information. How do we think about public sharing and why it's important?
Well, I think there's public sharing, and then there's sharing among sort of trusted partners, and I think they're two very different things. I mean, my sense from talking to people on both sides of this is that the government private sector information sharing has improved over the last couple of years, to the point that both sides, I think, are getting more actionable information. Although I see Aaron smiling, maybe he has a different perspective on this. Is it perfect? No. Is it a panacea? No. Is it better than it was? I think the answer is probably yes. So that's doing some of the work. But on the sort of incident disclosure point, I mean, it's also useful, I think, to think about the United States as one jurisdiction here. The European Union is considerably further along on this regime than the United States is. Under their Network and Information Security Directive, there is a sort of more robust incident response obligation. So for some of these companies that are operating internationally, they do have obligations to European regulators, not just to US regulators. And the disclosure obligations under European law can be considerably broader. So we can look to the United States could look to that as a model. I mean, one other way that this has been, to Aaron's question about sort of blind spots for the US intelligence community, I do think it's important that our intelligence community remains a foreign intelligence focused. And so those blind spots are in some ways there for very good reasons. But at the same time, clearly we do have some blind spots. And the National Defense Authorization Act that was passed at the beginning of January goes some way toward addressing some of those holes by giving CISA within DHS authorization to do kind of threat hunting on government systems that didn't have before. So these are small steps. I do think looking to the European Network and Information Security Directive might be a way to go in terms of the incident disclosures.
And if I can just say on information sharing, we've made great progress and come a long way, but we need more carrots in the soup, because right now for companies to go forward and share information, they have to risk years of civil litigation, multiple hearings before Congress, other questions that weigh against sometimes a more robust information sharing scenario. So I think that there can be some ways to improve that with better incentivizing of companies and with better protections from liability based on the information that is shared.
Yeah, I think that that's important. I think, Ed, where do you come out on this notion of increased sharing of information? You think it's valuable or not valuable?
Well, it seems like I'm being a bit of a curmudgeon today, so I might as well stay with it. If you graph the progress that we've made in information sharing, it is inversely proportional to the problems we've seen increase in cyber. So clearly, it's had no dent in anything that we've done. If just by analogy, if someone was going around blowing up power plants around the country, you wouldn't be talking about insurance. You'd be aghast. In fact, in cyber insurance is a form of legalized betting where you're betting that my defense will lose to some offense, where weirdly and bizarrely, the nation state offense can win anytime it wants. So it's a crazy, insane game from the perspective of a practitioner. But what you would do in the power plant case and what we should be doing in the cybersecurity case is re-architecting it. We need incentives. Aaron said it earlier, FireEye's incentive was commercial. We need incentives for the defense to do a better job. And we don't. I spent a lifetime in defense. There are no incentives to do things right. What's the incentive? I guess keep your job, maybe. There was no financial benefit to it. If you step forward to Judy and Kristen's points earlier, what's the benefit of bringing data forward to a sharing group? Really not much. In fact, it might come right back at you. So I think we have a very perverse set of incentives. And I think we've forgotten that network infrastructure and computing, these are man-made objects, and we really can redesign them. We can take the engineering steps to stop these attacks. And that's where all of our emphasis should go. I think all the incentives, all the legal discussions, all the investments that we make at a national level should be around improving our defenses. Did FireEye prevent this attack? No, they happened to see it happening. That's not preventing it. That's they stumbled onto it. So I don't call this a win. This is a big loss. And I don't think the government is going to do any better in monitoring. So I think we need to re-architect everything.
Okay.
While we're on the path of that, which I think will take time, there are some really good key takeaways in terms of FireEye had multi-factor authentication. That's how they detected it when they found a new phone was being added. So they called the person and said, did you just add this phone? That was the trigger, which is not very sophisticated to find an incredibly sophisticated attack. So while we're in the process of rebuilding all the defenses, which I think may take time, it's helpful for people to realize that some basic cybersecurity, following the framework and good hygiene with better password management, which didn't exist at SolarWinds, and multi-factor authentication, which did help detect this whole problem, and some other basic steps like cordoning off your most sensitive data can really help us while we solve all these other bigger, longer term problems.
Stay alive while we're fixing the house, right?
Indeed, right. A little scaffolding.
Practical consideration. I agree.
Yeah, I mean, I've been on many panels with Ed, and I know he's a firm believer in the basic cyber hygiene, which would be so helpful while we're re-architecting everything, and while we worry about whether it's an act of war or not, as Kristen has explained to us, or as Aaron has prompted us to talk about information sharing, which I really appreciate, Aaron. Good cyber hygiene is something we shouldn't forget, as well as remembering that for every corporate person out there, cybersecurity is everybody's business. It's not just the CISO's business, it's everybody's business. So on that note, it being 1:59, let me thank Ed and Kristen and Judy and Aaron for taking the time. I hope this was illuminating to many of our listeners. Thank you for many of the questions. I tried to cover them generally as best I could. And if I didn't, I apologize. So thank you all. Have a great rest of the week and stay safe out there from a cyber and other perspective.